As of March 19th, 2021, California employers with more than 25 employees are required to provide additional paid sick leave. On March 19, 2021, Governor Newsom signed SB 95 into law. This new law, the California Supplemental Paid Sick Leave, requires employers that have more than 25 employees to provide this COVID paid sick leave. Now, it only applies to employers that have more than 25 employees, and there's also different requirements set forth for in-home supportive services and firefighters that employers need to review the law for more details. Now, the employees that this covers are any employees that are unable to work or telework because of one of the qualifying reasons set out in the law. So there's 7 qualifying reasons that an employee can take time off of work that the employer needs to pay for. The first reason is that the covered employee is subject to a quarantine or isolation period related to COVID-19 as defined by an order or guidelines of the State Department of Public Health, the Federal Centers for Disease Control and Prevention, or a local health officer who has jurisdiction over the workplace. The second qualifying reason is if the covered employee, has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The third qualifying reason is if the covered employee is attending an appointment to receive a vaccine for protection against contracting COVID-19. The fourth qualifying reason is if the covered employee is experiencing symptoms related to a COVID-19 vaccine that prevents the employee from being able to work or telework. The fifth reason is if the covered employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. The sixth reason is if the covered employee is caring for a family member who is subject to an order or guidelines set forth above, or who has been advised to self-quarantine. The seventh qualifying reason is if the covered employee is caring for a child whose school or place of care is closed or otherwise unavailable for reasons related to COVID-19 on the premises. Now, in terms of the amount of paid sick leave that's required to be paid under the law, employees are entitled to 80 hours of COVID-19 supplemental paid sick leave if they are considered full-time employees, or if the employee worked or was scheduled to work on average at least 40 hours per week for the 2 weeks preceding the date that the employee took COVID-19 supplemental paid sick leave. Otherwise, employees are entitled to their total number of hours they normally are scheduled to work for the employer over 2 weeks, and if the employee works a variable schedule, then they receive 14 times the average number of hours worked in the 6 months preceding the date that the employee took the COVID-19 supplemental paid sick leave. The law also sets forth how employers are to calculate each hour of pay under the COVID-19 supplemental paid sick leave for exempt and non-exempt employees. The FAQs published by the government are great and have some examples on how to calculate the amount of time and the rate of pay, and I recommend employers take a look at those FAQs. We have those linked in the description below. Now, the supplemental paid sick leave must also be in addition to any other paid sick leave available to the employee pursuant to the Healthy Workplaces, Healthy Families Act of 2014, as set forth in Labor Code Section 246. Employers may not require employees to use any other paid or unpaid leave, time off, or vacation time before the employee uses COVID-19 supplemental paid sick leave. However, employers may require employees to first exhaust their supplemental paid sick leave prior to paying the employees under the Cal-OSHA COVID-19 Emergency Temporary Standards. For more information about the ETS published by Cal-OSHA, we've got a lot of different articles and videos on that through our blog. The law also sets caps on how much the employer needs to pay for the paid sick leave. Employers are not required to pay more than $511 per day and $5,110 in the aggregate to a covered employee, but this cap may increase depending on federal legislation. If federal legislation amends the caps set forth in the Emergency Paid Sick Leave Act established by the Families First Coronavirus Response Act, otherwise known as the FFCRA. So employers need to watch to see if on the federal level, if those caps are increased under the FFCRA, the caps under California Supplemental Paid Sick Leave will likewise be expanded. Now, it's important for employers to also abide by the reporting requirements that the new law implements here. Employers must provide accounting to employees by the next full pay period following March 29th, 2021. Now, so the supplemental paid sick leave needs to be set forth on a writing provided to the employee or on the employee's pay stub, and it needs to be set out apart from any other paid sick leave or paid time off. It needs to be tracked independently and reported to the employee under this new law. It's important that employers start working on that to make sure that this is timely complied with. California employers need to note that the law does apply retroactively to the beginning of 2021. So if an employee has taken leave for one of the qualifying reasons under the new law, and the employer did not pay the employee for that time off, the employer must pay the employee if the employee makes a request, a written or oral request for this paid time off. Now, the FAQs published by the Labor Commissioner explain that the employees need to make this request on or after March 29th, 2021. If they make the request before that date, it's not valid. And likewise, employers don't have to by themselves go back and audit all the leaves that were taken by employees. It's only when the employee requests pay for this leave taken prior to March 2021. We're also getting a lot of questions from clients on whether employers can require medical documentation for the leave to qualify for this paid sick leave. The FAQs have made it clear that employers cannot deny a worker the 2021 COVID supplemental paid sick leave for failure to provide any certification from a healthcare provider by the employee. Now, they do build in some reasonableness standards there, so if the employer has reason to suspect that the employee is not being truthful, there is a mechanism for the employer then to start asking for certification, but it's a sticky point, and employers need to approach that issue very carefully before they get into asking for documentation and medical certification before paying out the COVID supplemental paid sick leave.